So I get this person's purpose, their soul purpose, is a very giving, a light bringing to others, and it's unassuming, and it is the feeling I have is that it's that the people she encounters,
mm-hmm.
she gives them this kind of light, this kind of it's almost a kind of, I don't want to say wisdom, that's not the exact right word, but this kind of self-acceptance or gentleness, compassion, kindness. And she shares it with them in not a real strong teaching way, just sort of in a joking way,
mm-hmm.
but it's very light and gentle, but it's a very, just her whole energy is like bringing light to people around her. And I see her connecting with a lot of different people,
mm-hmm.
but all of them is like just a little light touch. She's like just unassuming,
mm-hmm.
but very loving and giving to a lot of people. And she really is a gem, but it's not really noted. She does it in such an unassuming way that people don't make a big deal out of her or don't really appreciate how precious she is as a soul. But she's giving, this is like her fulfillment is this giving of love and sort of helping people in their lives to be happier, to be kind to themselves. And she just shows that as like her purpose.
Uh-huh.
The defendants request to dismiss the indictment as an extreme remedy that is not justified. The discovery deadline has not passed. The state is aware of its obligation to continue to provide discovery as information becomes available. To prepare a report with regard to the tip information, we just want to clarify that this is 1,188 tips. This is 1,188 pages that contain information regarding the tips and a summary sheet. The tips themselves are sometimes small, and so while it sounds like a voluminous amount of information, many of these pages themselves are almost blank. But each tip was contained on a single piece of information or a single piece of paper, if that makes sense. There may be like a few lines at the top and then the rest of the page is blank.
Can you explain the delay in getting those turned over?
Yes. The state learned of their existence at the end of January. We were not aware that they were in the possession of law enforcement. The prosecution team learned of that at the end of January and provided it on February 2nd, as noted.
Of 2023?
I'm sorry?
February of this year?
Yes.
Okay.
Yeah, we learned, the prosecution team learned that they were in, I think, the Rexburg Police Department's possession, and they were in reference to the search again for Tylee and JJ, who were missing at the time. I should be clear, though, that and clarify that information that had been determined to be of evidentiary value or by law enforcement that was followed up on and investigated, that information was turned over earlier, but the substance of the reports, including, I think, as mentioned in our brief, psychics and visions and things like that, the rest of that had not been turned over. Again, the state disagrees with this characterization that these are Brady or discovery violations. In response to the defendant's reply suggesting that the state is obligated to provide copies in searchable format with an index that flags any potential Brady material, the state disagrees. The case law that was referenced by Mr. Pryor in his brief is persuasive authority, and it is not controlling. What is controlling is Idaho Criminal 16, which requires the state make such information available to the defense for inspection and copying. Evidence was disclosed previously or made available. This is true for the tips information as well. There may be some information that could aid the defendant in preparation for trial, but this does not transform the evidence from psychics or otherwise into material exculpatory evidence. Although the defendant argues that there may be some information related to alternate perpetrator theories, the state is under no obligation to single out particular pieces of exculpatory or potentially exculpatory evidence pursuant to Rhodes v. Henry. This information has been turned over in a reasonable time frame for the defendant to make use of in trial preparation and before the deadline for discovery has passed. Again, any relevant information from the tips was provided previously, but we acknowledge that the substance of all of the tips was turned over very recently once the prosecution team learned of it. And we were unaware that they had not been, that the full tip file, I guess, for lack of a better word, had been turned over previously. Once we learned of that, we did turn it over promptly, as mentioned.
All right, thank you, Ms. Rawlings.
Thank you.
Prior response on that.
Judge, a couple of things. I want to point out, I'll start with the tips. 1,188 pages. It's a mischaracterization to suggest that each page has only one tip. I've discussed this with Mr. Thomas, Mr. Archibald. Quite frankly, there are a number of pages that have 3 or 4 tips. But there are 500 tips. 500 tips on 1,188 pages. So the concern is this, Judge, is that these tips have been in possession of law enforcement behind me, some of them, for a significant amount of time. And I did misquote counsel. You're correct. June 2020 instead of 2019. I apologize. It was June 2020. You're correct. So rather than 3 years, Judge, it's only 2.5 years. So it's only been in their possession for 2.5 years while they've sat on these tips. Judge, this isn't a situation where you hand me 500 tips and say, well, this is information that we got. We don't know if there's any value to it or not, but here it is, and we gave it to you on February 2nd. The notice obviously filed February 5th. 21 days, 3 weeks ago, Judge, they gave me 500 tips. Oh, we inadvertently forgot to give that to you. That's not an excuse. And all of the case law in the Supreme Court has repeatedly said that the police and the prosecutors are under an obligation, and the prosecutors are under an obligation to determine and get information to the defense attorney. This isn't a situation where, I have to track it down and say, oh, by the way, I didn't see any tips that you gave. Are they there? No. They suddenly discover, Judge, that whether, and I want to be careful, whether the police have been sitting on these or whether the prosecuting attorney just discovered these, it doesn't matter. The fact is they're providing me 500 tips, and now I'm getting those, what's in essence just 5 or 6 weeks before this trial is supposed to start. And I'm supposed to spend my time going over 500 tips to determine whether there is any information on there that potentially could be exculpatory. That's just one piece, Judge. I appreciate counsel pointing out that, well, we only gave Mr. Pryor summaries when we gave him the information. I would beg to differ on her explanation, Judge. On the GPS, it was a face sheet. On the Faro scan, it was a face sheet. On the 12 terabytes of evidence, it was a reference and a small amount of journal entries. And then what had to happen, Judge, is I had to file a specific request for discovery when I passed that information along to my experts, and they said, where's all the meat and potatoes of the evidence that they didn't provide? Where's all of this information that they did not give us? And then they provided that to me, Judge, and that's only been done in less than the last month. So in the last month, even though they've had a preliminary hearing on the original charge where their expert got up there and talked about waypoints 3 years ago, and then they have a grand jury proceeding, and there's discussion about that as well, and then suddenly now in February, after all of these steps, they provide me 500,000 waypoints that I'm supposed to process. And I didn't hear an explanation as to why they mishandled the evidence. I didn't hear an explanation as to why they weren't able to provide me all the evidence. What they did provide is an explanation saying, well, we just discovered that, oh, by the way, we didn't give you all the evidence in a capital murder case. We've just discovered that oops, sorry, but here it is now, and you're supposed to be ready. I'm sorry we didn't get it to you in time. I'm sorry that, oops, our mistake because our police aren't doing their job, and their incompetence has stopped us from getting evidence until 30 days before trial. And if this court decides to go forward, go forward. And I will make representations that I have not had sufficient time to test DNA evidence. I was provided tips at the last minute of information that have been sitting in the police officer's possession, and by association, this prosecutor's possession. The Faro scanner that they provided me was a piece of paper that said, hey, there's a Faro scan. And then I had to do a compel to get the rest of the information. The same thing, the summary they talk about with the GPS were a couple of pages, and then I had to turn around and say, give me the 500,000 waypoints, and that just happened in the last month. The chain of custody was just provided to me 2 days ago. The 12 terabytes has not been provided to me.
Indictment, Mr. Pryor, you've also got a separate standing motion to sever. That was filed on February 13th. The state filed a response to the motion to sever on January 13th, and then a supplemental response also filed by the state on February 21st to the motion to sever. You've touched on some of those issues already in your first argument as it relates to severance, but if you'd like to now argue the motion to sever, you may.
And Judge, for the record, I believe my motion to compel deals with the DNA evidence, and I think the court directed that appropriately. If the court wants to, we can skip over that motion to compel, because I feel like if the court's going to be notified, I assume then that I'll be notified what the results are, and that should resolve that issue. So we can move on from there in terms of the motion to compel.
Very well. Ms. Blake, did you want to address directly the motion to compel?